Okay, I'm going to give you an overview of employment law. This is obviously very important for students in businesses. Obviously, we're either an employer or an employee, so important to understand these basic concepts. The premise you start out with in employment law is, first of all, understand that first of all, you've obviously determined that the worker is an employee, that you've exercised enough control that they're now deemed an employee liable for the state and federal employment taxes, minimum wage, etc., and you're liable for the employees' torts and contracts executed within the scope of their duties. The starting point on employment law is the presumption that the employee is employed at will, which means that they can be terminated for good reasons, for bad reasons, so long as it's not illegal, right? Now, there are a number of exceptions to this presumption. So, like many other areas of the law, you'll see there's a presumption that can be rebutted. So the presumption is you're employed at will. You don't have a right to the job unless you have some sort of contract, right? And the contract, again, can be oral or written. Remember, the statute of fraud says a contract which by its terms cannot be completed within a year has to be in writing to be enforceable as a contract. So you can have an oral contract, you can have a written contract. A collective bargaining agreement can be a contract. It is a contract, so that might provide you some protections. Typically, collective bargaining agreements have progressive discipline, which benefits the employee and inhibits automatic discharge. What I suggest to students and businesses, always document what you're doing when you hire somebody, so there's no dispute as to the expectations of both parties. And again, that goes back to the basic element of an offer and acceptance. So, and contracts, again, that can be fairly broad. Sometimes a handbook, depending on how it's written, could be viewed as a contract. But it depends on the circumstances. Oftentimes, handbooks will have in the front of it saying a statement, this is not meant to be a contract, don't rely on it, but if you violate it, we're going to discipline you. So it's sort of a counterintuitive in a lot of ways. Another exception to the employment at will doctrine is wrongful termination. That's a type of tort or wrongful discharge. It also goes under. This is where you're terminated. Could be in violation of a contract or because you're a whistleblower or something that violates state or federal law. Let's say you're pregnant or something some discriminatory animus that has motivated your termination. And this does get into public policy. Public policy is not only statutory protections that are afforded to employees, workers, but also broader than that. There's actually cases where people have been terminated for something that clearly violates their contract, but the circumstances were such that public policy views it as, or the courts view it as unfair to terminate somebody for engaging in conduct the courts want to promote. With respect to discrimination, let's talk a little bit about that. There are two basic types that you'll see. Discriminatory treatment or disparate treatment, where you're treated upfront differently because of your protected class, age, race, sex, disability, veteran status, sexual orientation, whatever. Those, where upfront there's really no mistake that you are being treated differently because of that. That's called disparate treatment. Disparate impact is a little more obscure. There's a policy that on its face looks pretty benign, but the impact of the policy ends up discriminating against you or someone that's in a protected class. Your book talks about this. Most common is disparate treatment cases. And this gets to our discussion of harassment. Harassment, very big problem, very big problem. This is where employers don't understand the liabilities associated with harassment. And again, we talked about the responsibility of employers for their agents, for their employees. This gets to the point of responding at superior, in how employers are responsible for harassment perpetrated by their supervisors. Also, employers are responsible if they knew that customers are engaged in some sort of harassing behavior. Now, harassment boils down to two basic types. Now, we often talk about sexual harassment, but it can be anything. It can be harassment based on disability. It can be ethnicity, race, obviously. So it's more than just sexual harassment. There's the quid pro quo type of harassment that it's if you do something for me, I will reward you with some sort of terms and conditions of your employment will improve if you do something for me, maybe a sexual favor or something like that. That's a quid pro quo situation. Normally, employers aren't that stupid. They're not going to have that happen. More common is a hostile environment. This is where the environment is so hostile, a reasonable person wouldn't stay there. So you end up leaving normally, and that's called a constructive termination, where it's just intolerable. You walk away and you are a victim of harassment. Now, normally with harassment, you have to notify the supervisor that there's some unwelcome behavior going on here, normally. Now, smart businesses will have a policy that addresses harassment, has a mechanism for complaining, has training, and these are all defenses an employer can use, saying, well, we had a policy, we did training, and this person who's claiming harassment never afforded themselves of those of the policy, of the procedures to complain. They never complained, and we did the training, etc. Those are all defenses smart employers will utilize, but it does require some thought beforehand. There are a plethora of federal and state and local anti-discrimination laws. So on the federal level, it's called Title VII. Prohibits discrimination in employment. There's age discrimination laws. There's disability discrimination laws, etc. States, as we discussed initially, actually recognize more protections. State of Washington protects against discrimination based on sexual orientation. The federal government, Title VII, doesn't address it specifically, although some courts have. And when we talk about labor laws, think about minimum wage, overtime, federal government, Fair Labor Standards Act. State of Washington, we have a Washington State minimum wage law that gives you more per hour, and local governments have even upped that to the $15 an hour campaign type of thing. So those are all things to be aware of. There are again, a number of defenses that employers can raise with respect to discrimination cases, but there's huge liabilities here for employers if they misclassify. Again, if they misclassify a worker as an independent contractor and they don't pay minimum wage or all the other required state and federal mandated taxes and things like that. The other one that to be aware of is that even if you do have an employee, there is a distinction between those that are subject to the minimum wage law, which are non-exempt employees, and those that are exempt from minimum wage and overtime. There are like 4 categories: administrative, professional, computer people, things like that. Very narrow exceptions to the minimum wage laws. The person has to meet the statutory definition of true administrative supervisory person and making a certain amount per week. That is in flux, but you just can't unilaterally tell somebody who's an hourly worker that suddenly they're exempt from minimum wage. A lot of businesses do this because they really don't like the burden of paying minimum wage all the time. It's a record-keeping hassle. An employer that doesn't follow the minimum wage laws, whether it's federal or state. They get sued by a worker. Normally, it's going to be a group of workers, and attorneys specialize in this. The courts will rely on the employees' record keeping if you haven't kept records. And the attorneys love these cases because they get statutory attorney's fees from you, which can dwarf what you owe the worker. So it's far better to understand the law and behave appropriately in response.